Ladies and gentlemen, I am Megha Gupta and I am your host for the session today. Good afternoon and welcome to the Webex session. Our enforcement agency is behind you. Do's and don'ts. We have a special guest speaker, Mr. Siddharth Luthra, Senior Advocate, Supreme Court of India. From NDA, Vyapak Desai, Pratibha Jain, Payel, Chatterjee and Alipak Banerjee will present the session. Please note that this session will be in listen-only mode and will last for about 60 minutes, of which first 40 to 45 minutes will be spent on panel discussion. The remaining time will be available for question and answer. We request all the participants to post their questions in the chat window while the panel discussion is on. The moderator will queue up the questions for the speakers accordingly. Should you need assistance during the conference call, you can use the chat option. You may note that this conference is being recorded. I now welcome our session presenters. Siddharth Luthra is a Senior Advocate, Supreme Court of India. Vyapak Desai is the Head of International Dispute Resolution and Investigation Practice. Pratibha Jain heads the New Delhi office of Nishith Desai Associates. She is a leader in the funds and regulatory practice. Chatterjee is a leader in the international dispute and insolvency resolution practice. Alipak Banerjee is a leader in the international dispute resolution and investigation practice. Lastly, but importantly, all participants are requested to put their phones on silent mode. Over to you, Vyapak.
Sure. Thanks a lot, Megha, and thank you everyone to join this session. There is an overwhelming participation on this session, and we are very happy to see the interest in this subject. So, while this has been always an important subject for all the corporates in India for a long time now, particularly with the kind of risks and liabilities that it may generate. But I think it all possibly started with some of the uh, scams or some of the issues related to fraud, uh, money laundering, and other corporate frauds that came up from Satyam Saga to 2G Spectrum to Colgate scam. And recently, we have seen a lot of uh, interest in this subject, particularly in light of the issues that have been raised in, in light of the ILFS, Yes Bank, Jet Airways, DHFL, PMC Bank, and so on and so forth. So we know this subject has been always been in the minds of people to understand how these things work, why people fear regulators in India, why people fear enforcement agencies like the Enforcement Directorate, the SFIO, or even in some cases the SEBI investigations, which ultimately lead to prosecutions and penalties. Uh, One is they have wide-ranging powers. Post the amendments which were passed in last few years, they have been empowered to conduct inquiries, to practically attach or confiscate assets derived out of those scheduled offenses. The ambit of the act is widened over the years, and we have seen unprecedented powers to arrest even granted, which we saw recently in some of the high profile cases as well. So with that background, we thought that this topic is very important, particularly when the economy is going through a critical stage and a downturn caused because of COVID and other reasons. Some of these frauds uh, possibly may actually increase uh, because of the stress on the economy. Uh, in fact, even without that, the recent statistics say that there are more than 2,500 cases under PMLA and more than 16,000 cases under FEMA, which the Enforcement Directorate is prosecuting at this stage. So, with that background, there are obviously a lot of practical aspects that we want to cover. We want to obviously cover a lot of legal aspects related to both frauds related to India and also having impact on the international businesses. With that introduction, I would like to invite Pratibha to give a sense on some of the experience that we as NDA and she has in terms of the enforcement process. And then we will go to Mr. Luthra himself and Payel and Alipak on some of the legal aspects. Over to you, Pratibha. Till Pratibha comes in, maybe Payel, if I may get you in
Yeah, I
for
didn't
a
realize
quick.
Vyapak, I was on mute. Sorry about that.
Sure, sure, Pratibha, go ahead. Payel, I'll come back to you little later. Yeah, go ahead.
So thanks everyone. Just to outline, why this topic is so important for the audience today, which is a mix of corporates and fund professionals. This is the ED and CBI have been the two important institutions that have been prosecuting white collar crimes. Just to give you a sense, since 2017, there have been 11 convictions in just 8 months of 2017 itself, as opposed to just 3 between 2002 and 2017 under PMLA, which just shows that these authorities have become much more active. The number of, not only the number of cases have increased, but number of convictions have also increased. And there has been a focus on corporate frauds. There has been, of course, focus, as we've seen. There's a lot of political activity with respect to these institutions, but because these are all economic offenses in nature, we've seen our clients getting caught in crossfire, even where some of these are, seen to be politically motivated prosecutions, where you might have foreign investors investing in companies that are under the scrutiny of these regulators. The nature of these authorities, and also with the recent amendments that Vyapak briefly mentioned, have given them such wide ambit that the usual checks and balances that are available when we go to court for a civil or a criminal proceeding even are not necessarily available when you're going in front of ED or CBI. And that is why that raises a fear amongst especially the white collar, the corporate world, that the other proceedings don't. The amendments that were made recently have given ED unprecedented powers. It can arrest an individual even without an FIR. All the offenses are now cognizable and non-bailable. Under PMLA, a statement recorded before an investigation officer is admissible in court as evidence. This is not what we are typically used to. And defending our clients in front of these investigation agencies also becomes much more difficult, because the standard checks and balances that are available to us under law are not necessarily available these days. It's been very interesting to also note how CBI and ED have been working on cases not together but simultaneously. So, for example, the prosecution of Mr. Chidambaram and some of the others in recent cases showed how, even though we were able to get as lawyers bail in one matter, there would be proceedings in another matter. And so the overlapping jurisdiction, even though it's been said that would not be there, we've seen in certain of these cases, which are in huge public limelight, have both CBI and ED investigating, which just complicates the issues. In our practical experience, it also creates a lot of issue for not just the accused in question, but if there is a corporate that is named in an FIR, then the independent director or the non-executive director or along with the executive director, gets named in the FIR, because the logic that we've heard from these regulatory authorities have been behind the corporate, that the individual we are going to go after are the directors till they can prove that they're not guilty. Even if the directors were not a director of the company at the time the alleged offense took place. These complications are the reasons why how we deal with a CBI or an ED case is very different from how we do our other normal litigations. I will just briefly stop here and see if Mr. Luthra has joined us, because he's really the master in terms of dealing with these authorities and cases with these authorities, not the least because he himself has represented these authorities in various matters and courts. So his insights today are going to be extremely important. Mr. Luthra, have you joined?
I think we can't hear him. Can you be a little closer to the phone, Mr. Luthra?
Yes, of course, I will. Give me a moment.
Okay, while he joins us on the main line, Payel, maybe you want to just start briefly with the background on the powers of these agencies.
You are on mute.
Am I audible now?
Yes.
Yeah. Thank you, Pratibha. So briefly touching upon the powers and functions, the first aspect actually which Vyapak and Pratibha both dealt, that there are several laws and schedules of offences which the Enforcement Directorate deals with. But primarily they look into the financial crimes and economic offences, and three main legislations which get covered under the domain of the Enforcement Directorate include the Prevention of Money Laundering Act, as well as the FEMA offences and offences under the Fugitive Offenders Act. Now, primarily, what is the scope of the Enforcement Directorate? It does not directly register a case. What it does is, post a case being registered by the police officials or the CBI, that is when the Enforcement Directorate comes into the picture and gets into the investigation mode. They primarily look at offences which are economic in nature, and try and see whether they would go ahead with search and seizure. They would go ahead with identifying, tracing, as well as also locating the particular individuals behind the offences. The freezing of the assets would take place, and in this process, they can actually freeze the assets which are basically acquired from the proceeds of a crime. Now, the context of proceeds of crime is extremely critical in this particular nature, because of late, they have expanded the definition of proceeds of crime itself. Now, I think Mr. Luthra will deal in detail when it comes to these particular issues. So I would like to invite Mr. Luthra to give his comments on the powers, functions, and in detail about the Enforcement Directorate's functions.
Hi, can you hear me all now?
Yeah, perfect. Please go ahead.
We can.
And can you see my face? I'm sorry about this. I thought I'd got this done on my iPad, but there was a problem clearly with that and it wasn't working. Okay.
The video seems off. If you can switch it on, then we can see you also.
Of course, I'll switch it on. Of course, I'll switch it on. Of course, I'll switch it on. Is it on now? Otherwise, it will come on. It's on?
Yeah, it's on. We can see you, sir.
Sorry about this. One of those days when everything that must go wrong does go. Okay, I'll tell you what. First of all, apologies once again for being rather very obnoxious, very late, but technology is clearly stands in my way as it more often as
so
it
much
does.
for joining. Your time is so precious, so we really appreciate it.
No. It's a pleasure to be with you guys today. Okay, let's understand what we're dealing with, because the lay of the land when it comes to corporate criminal liability, and that's what you're going to look at, because you're not going to do hurt crimes unless somebody is planning to commit murder one of these days. being stuck up so long, cooped up inside the indoors. That may be a grouse for a spousal crime or a crime. But that apart, we're looking at a number of agencies and we need to understand how these agencies function. So the agencies are going to be the CBI, which is the Central Bureau of Investigation, the ED. And the reason I'm mentioning all these agencies are because your interaction as a corporate practitioner, corporate litigation practitioner, is going to be with the CBI, with the Enforcement Directorate, with now increasingly the Serious Fraud Investigation Office. That's a big one and very important. The Directorate of Revenue Intelligence, which deals with customs and excise matters. Then you have the DGCEI, which is the Directorate General Customs and Excise Intelligence, Central Excise Intelligence, and also the NIA occasionally. Now you'll be wondering, why am I telling you about the NIA? It's a very odd thing. But you know, the NIA also deals with a class of offenses which will be relevant to you. And that makes it a very important body so far as you're concerned. And that is the whole purpose to talk to you about the NIA today. So that's one. The second issue is that apart from all these investigating agencies, we also have a situation where they have two sets of powers. And no, I must add one more thing before I go a little further. There's one more important thing which I must share with you, and which is this. We also have the economic offenses wing, or the cyber crime, or the CBI, CID of various police agencies. Now, these are all very important. They operate in two sets of environments. The easiest environment for them is, of course, the CRPC, which is where the CBI will operate or the state police will operate. Even the NIA is subject to its own statutory powers. The second set is very interesting because the second set of powers are powers under the special laws, for example, the PMLA or the now the FEMA, the Black Money Act, where the income tax also operates. And these are powers which are vested in specified agencies and not, as I said, with specified statutes and specified liabilities. Now, why does this become very important? Why it becomes important for us is because when you are asked to join an investigation, let's say a summons reaches, there can be two kinds of summons. The first summons that's going to come to you is a summons essentially to supply documents, which is an easier one. It's not that complicated. You're asked to supply documents. You go across and you supply documents. The second one gets a little more complicated when you're asked to supply not just documents, when you're asked to appear in person. And for any corporate client, that's a problematic one, because that's when there are pressures that mount on the lawyer as to how do you ensure that the client is adequately represented and protected. Why am I taking you through these two kinds of agencies? The reason is statements before specialized agencies are admissible. So when you record a statement, these are admissible. I must also share with you that in the past decade or so, there have been three sets of challenges to the functioning of these non-police agencies. A challenge is currently pending, whether they can or they cannot register, investigate without FIRs, whether they can investigate dehors the CRPC, because what they really do is they'll record an information in terms of their internal manuals, which nobody has seen so far. The CBI manual is available, but the ED, the SFIO manuals are not available, the DRI manuals are not available. And then they go and they detain people or summon people, question them, and you really don't know the basis of information on which they're being called. So this becomes very important for us. And the reason I'm raising this issue is because this challenge is pending, and in about 100 odd petitions, the bench headed by Justice Nariman has actually stayed proceedings because the provisions under the CRPC, mandatory provisions, have not been followed. Of course, later on, when Justice Gogoi took up these matters, he was not very impressed with these stays of investigations, and therefore the matters have been transferred to another bench and they are lingering somewhere in the gray zone. But it's a legal challenge. Now, let's look at it. What happens when you're called for the first time? As I said, we started off by telling you, you'll either be given a summons to enter appearance with in person. So the summons may say you're directed to appear in person. Sometimes these standardized formats contain in person or through pleader, in person or through authorized representative. If such an option is given, it is not mandatory to appear in person. It's a different matter than orally call up and insist you appear, but you don't have to appear in person, and that nuance in the summons must always be seen. The second issue is, supposing a summon comes and it requires production of documents. Production of documents is not to be done necessarily by the person concerned unless there is a personal presence sought. So you can always send that to a representative. Now let's look at it. Let's divide these into two categories: production of summons for a witness, or for documents, or for recording of evidence. If it is only documents, one of the important things you must consider is, who are you sending with the documents? Is it a person who's a mere record keeper? Or is it a person who has knowledge or who of the issues under investigation? Ideally, you should send a person who's really a document supplier, who's not connected with the matters at hand, so the person can simply answer in the event a statement is sought to be recorded about the documents. Because very often when you go in like this, the investigating agency is saying, all right, you're here, please explain the documents to us. And at that point, if some genius decides to venture an explanation on the documents, you have a serious problem. You don't want that. So the person who's going to supply documents must be adequately briefed that his or her mandate is only to supply documents and no more. And his or her mandate is not to give an interpretation or authenticate the documents. Unless all he's doing is an authentication that these are true copies of the original. Beyond that, the person's mandate should not exist. And the person must be explained. They may have heard, but don't have personal knowledge. That's part one. The more crucial one comes is when you're asked to appear in person or through pleader. So as I said, draw the distinction between appearance in person or through pleader. Don't necessarily appear if you're only asked to be represented by someone. And if it's not struck off in the summons, don't necessarily volunteer to appear in the first date. One of the practical things we do, and these are things you will not find in the CRPC, you will not find in the police manuals. These are things which we practically do is, we often raise a preliminary request asking for information, asking for the information which is the basic of this investigation. 9 times out of 10, in fact, 99.9% times, you're going to get an answer that they're not providing that information to you. So if they're not providing that information to you, we have to keep persisting, but at the same time, you will, knowing the nature of the agency, the questions that they put to you, because very often a summons is accompanied by a series of documents sort of a questionnaire, or if they do a search and seizure, you become aware of what is sought. And that becomes a little crucial. You are really, you understand the kind of information that is being sought from you, or what is the nature of the complaint. If that be the case, we now have to work around on our hypothesis as to what is the possible cause of action as against us. Because, we also know the jurisdiction of different agencies, so we know which is the area they're likely to be investigating. Very often the summons will also mention the provisions which are invoked. So let's say in a Companies Act prosecution, if section 447 is invoked, you know it's a case of fraud, right? And therefore you have to meet that investigation of fraud. So that's one aspect of looking at it. Now, if you're called, as I said, you have a right to be represented by a counsel who is entitled to appear with you. But the point is, do you want to take a counsel necessarily? Legally, you're entitled, and I must tell you, there has been an unfortunate dilution of the law. You're all aware of the Nandini Satpathy judgment, 1978, aren't you? Have you heard of Nandini Satpathy? Nandini Satpathy was the Chief Minister of Orissa. Sorry, can you not hear me well, Pratibha? Is there a problem with the mic?
I can hear you. Sorry, I was on mute. I actually haven't read that judgment.
No, but then you must read it because all of you must first read Nandini Satpathy, which is 1978 to SCC 424, I believe the citation is. There are 4 or 5 Nandini Satpathy judgment. This is on the right to be represented by counsel and when you become an arrestee. And it talks about the right against self-incrimination. It's a very important decision. And I'll tell you this, the problem that you face is, listen, I'm getting some notes on the screen. Do you want me to respond to them now or later? The stickers on the screen, they're just...
Go ahead, we can answer the questions later.
You can put the questions later, I have no problem. So, because I'm only getting half the questions, not the whole questions, and that's the problem. So I get
I will read out the questions, so don't worry about it.
No problem. Please give me the question. That's hardly an issue. That's what I'm here for. I'm right now in Pratibha's custody, so I have no option.
Presented by counsel, don't worry.
Sorry? I don't know, Pratibha. All these people on your side, I don't know whether anybody will be willing to file a vakalatnama for me. They'll all plead a conflict and I'll be in trouble. They'll say, we are all associated with Pratibha, we can't touch your brief. Now, although I did delay coming into custody by about 15 minutes today, but I'm finally in your custody. So, just to tell you, we are now ignoring the Nandini Satpathy principle because along came a judgment called DK Basu. I'm sure you heard of DK Basu.
Yes.
1997 Supreme Court. DK Basu is, according to me, is not my favorite decision. The reason is because it really tries to give teeth to provisions already existing in the CRPC, which frankly they didn't need. The only rationale seemed to be that if you don't follow the processes under the CRPC, then there needs to be some kind of action against the police officers who breach those processes. But in doing that, DK Basu lays down a terrible condition which says that you can meet a lawyer during interrogation, not throughout the course of interrogation. So prior to 1997, we as lawyers, and I'm of that vintage, had the right to spend the whole night in the police station, sitting outside on a chair, while our client was not being interrogated because they're not supposed to be interrogated at night, and even be there in the day. So for young lawyers, newly minted at the bar, it used to be a great opportunity because they'd get a watching brief, which was really watching the client while he was being interrogated, but you couldn't hear or interview. DK Basu, of course, adds one very important fact. It says that all investigating agencies will be bound by the directions contained in. So that's the positive part of DK Basu. Now let's come back to what happens when you get a summons and let's say you want a lawyer to represent you. As Pratibha raised with me in the conference we had on the last occasion, most agencies will not even let your lawyers come in and they'll say, wait at the gate. The remedy is go to court. You don't even need to go to the High Court, just go to the magistrate's court. And the magistrate will enforce the order. There is no option but for the magistrate to enforce the order. Very rare magistrates would dilly or dally, and especially during the period in police custody, there is no reason that you will not get this relief. Now, let's now come to the stage 2. A summons or a notice has been issued by you for production of documents, and I'm going to divide them into 2 categories, production of documents and statements, because both are very important. And there are different nuances to both. If it's a case of production of documents, we must first possibly try and analyze what we are supplying. If you don't analyze what you're supplying, or you miss out crucial exculpatory documents, you have a serious problem in your hand. Have you heard about this or read about this judgment called Shiv Kumar Jatia, which is 2019 or 19 Supreme Court?
That's correct.
I happen to appear in that case, so I can share a little insight on that. It's a very interesting case because there was a incident which took place in a prominent hotel. It's a reported judgment, so I can tell you the name of the hotel. In the Hyatt Regency in Delhi, where a young man climbs on the parapet of a wall, falls down, has an accident, and then decides to prosecute the management of the hotel. Now, the managing director is traveling that day, he's not in India. His simple answer is that if I was not in India on that day, there is nothing I could have done to stop that man or to take any precautions or to take any action in ensuring that the person reaches hospital in time, and not because that was one of the allegations made. And therefore, you can't hold me culpable apart from the fact, the general vicarious liability principle. And in that case, incidentally, the crucial document showing his absence from India did not get filed with the police. During the course of a conference about 2 years into the hearing of the matter in the High Court stage, the person concerned, the petitioner Shiv Jatia, sitting with me in a conference, lamented the fact that he was not even in India when this happened, at which time I got the shock of my life. And I told him, I said, Mr. Jatia, you've never told anybody that. He says, yeah, it just slipped my mind. We immediately moved the documents and record. The police affirmed that. Though the High Court rejected the petition, that became one of the grounds for quashment in the Supreme Court, and we succeeded in the Supreme Court based on this very material alibi document, which should have been placed on record at the investigation stage. So that's what I mean, that you must, as a client, as a lawyer, ensure that your client shares with you all inculpatory and exculpatory material, so you're in a position to determine A, how the inculpatory material must be placed, as in, do we need to put explanations? B, how exculpatory material must be brought on record, so that even if the investigator does not use it, you have a right in terms of the Nityanand case to get that summoned. I don't know if you've seen the Nityanand case. It's, I believe, 2017 or 18 Supreme Court. Just have a look at that. This is that case from Karnataka. I'd been amicus in that case, and we got it clarified that non-relied upon documents, those seized during investigation, can be sought by an accused. There was ambiguity in the law in the sense that the Supreme Court had not accepted this proposition in the judgment in it's a 93 decision. The name will just come to me, and that needed to be clarified, because that had said that even at the state of consideration of charge, accused can't place documents on record. However, finally, the Supreme Court accepts that though the documents which are already seized with the investigator can be summoned and can be considered at the stage of charge, because as you all know, in a criminal case, there are 4 stages. Cognizance, where the magistrate acts on his own. Summoning, where the magistrate again acts on his or her own. Charge, where you as an accused have a right to be heard, and then final judgment. Now, at the charge becomes for an accused the most crucial stage, because that's the stage when you have a right to be discharged from the proceedings, when you are right to be exonerated without having to face a full-fledged trial. So that is the most important stage. I'm not going to get into it's a different topic, but just to mention to you that, as an aside, that in a magisterial trial, even in a police charge sheet case, an accused has the right even to get himself or herself examined at the stage of charge to bring out their own version or identify or explain documents on record which are exculpatory and not inculpatory. So that's a very important aspect which we must consider. I think, Pratibha, I'm running a little out of time, I know, but I will try and wrap this up as soon as I can. So just let me know how long you let me meander on.
I think you have a hard stop at 4. Otherwise, we can continue.
Because it's 4:15 is when we have to end now. So we'll do a stop.
Pratibha, you want to take a couple of questions at this time, and then maybe he can come back on his topic.
I think
so
let
that
Mr. Luthra finish, and then we can take.
I'll tell you what we'll do. I'll do another 10 minutes. I'll wrap this up in 10 minutes, and then you can put all the questions, because I think some of the questions may get answered in the next 5 minutes.
sounds perfect.
So now, as I said, this is so far as documents are concerned. So exculpatory and inculpatory documents must be carefully placed. They must be considered. And also, you must remember that there are documents which are, let's say, drafts which are lying in your files. There is a tendency to hand over everything. I'm not saying one should not cooperate. Cooperation is required by the law. But if a document is sought, please give the final document and not a random draft which may contain office notings, which may sometimes give a different perspective than the final document which is signed, especially in the context of investigations in relation to government contracts. This becomes a very important thing, and most people tend to ignore this. And this is a very sensitive issue. Of course, if they search and seize them, then they'll have them, and then you have to establish it in any case. The second thing is, let us say you're called for an interrogation. Again, there are two or three rules of thumb. Rule number one, the person going for interrogation must be worked through their understanding of the facts. You must walk them through it. You must make them understand no guessing, no hypothesis, no explanation, no identifying. They'll have to, while the agencies sometimes get a little clever and tell you to identify a document. Now, you may identify a document as you have seen it before, but not that you're the originator of it, not that you're the supplier of it, not that you're aware of the contents. So you will have to, as a witness or an accused, a person of interest in a criminal matter or an investigation, clarify that if you are asked while during an investigation to identify a document, you will identify the signature and not the document if you don't know the document. These are, as I said, tips which you're not going to find in the textbooks, but I thought that is crucial to share them with you. Secondly, prepare people to answer in limited terms and not to give elaborate verbose answers, because verbosity leads to more questions, and the more you're asked, the more you're likely to trip over. And please remember that barring the police agencies, CBI, NIA, unless they're working under special acts, or the state police, all these statements are admissible. They can be the basis of a prosecution and conviction. So you have to be very, very sensitive while answering to agencies which are not police agencies, and therefore their statements before them are admissible. Having said that, there must be cooperation. There must be a failure to cooperate often leads to arrest. So in a simple case, the Bushenstein's matter, for example, there are 2 people out of 287 who've been arrested because the rest cooperated. 2 they arrested because they thought they were the main people involved. 1 is on relief, 1 is in custody, but they didn't arrest the others. So cooperation often is the key to avoiding arrest. Having said that, the moment a summons comes, we must also interact with the client and the representative and do an analysis as to the likelihood of arrest. If there is a likelihood, then remedies such as anticipatory bail must be considered, or in some cases, for example, in the Companies Act, as of now, there have been a number of challenges to the vires of the provisions, and therefore those questions are now being put up, and in those petitions, interim orders have been granted. We also got an interim order from a client from the High Court, was modified by the Supreme Court, but the person remains at liberty. So this is, in short, the arrest concerns. One more thing which needs to be highlighted is when you're engaging with investigating officers, as I said, cooperation, but not self-incrimination, not a confession. Reckless statements can lead to problems, and pre-being called, you would have, as most prominent law firms in India do, a lot of overseas clients. Now, especially with the UK Anti-Bribery Act or the FCPA in the US, United States, there is a problem with those entities who are FCPA governed, because in the event of corrupt practices in other jurisdictions, they have to report back to the Securities and Exchange Commission. It's all very well, they pay a fine and they get away with it, so the principal gets away. but the SEC puts up all such fines, liabilities on their website. For many years, the investigating agencies of India just wait and watch the notings, the prominent notices on the SEC website, download them, and then start investigation based on that. It started off, I think, about 20 odd years ago with the Xerox case, and since then it's a common practice. And all these investigating agencies, then after they begin the investigation, make one request of the Indian entities, and that request is as follows: that in terms of FCPA, you have to have an internal inquiry, and investigators are sent over, often from the US or from whichever jurisdiction they're based in, to inquire into the conduct of the Indian subsidiary. That report is prepared by recording statement, by seizing documents or copies of documents, authenticate documents. The Indian agencies just ask for a copy of them. The moment they only they ask for a copy of the report, because for them, that report is 3/4 of their job done. And while this process happens, there's another serious concern. The number of emails that we generate between clients and lawyers. Now, it's all very well that there is privilege attached to counsel's work. And that is why very often we advise law firms even to analyze, documents, financial documents of a client, that rather than the company, the client itself engaging the financial consultant, it's the law firm who will engage the financial consultant for the purpose of privilege claims. But if the client has all these letters and emails and analysis from the lawyers floating around in their records, and during a search, they fall into the hands of the agency, you have a problem with your hands. So this generation of electronic documentation about a pending investigation or a proposed or a likely investigation of a client is an absolute no. If clients want it documented, it should be as we're doing it on WebEx or otherwise. I'll give you recently we had a case where during a conference, the clients were consulting counsel, and counsel advised them that if a certain category of documents are produced, they're likely to be treated as forged because of dating and age, etc. of the paper. A diligent young professional noted down all those points. There was an income tax raid initially on the client's premises, income tax or whatever, one of the agencies, income tax I believe it was. And then they landed up at the lawyer's house and they got hold of this law. Because the client documents and computers there, and in the process of the clients picking up the client's files, personal files, not confidential files, that note surfaced, and that became an embarrassment for the lawyers. So we have to be very diligent. I understand that all lawyers, law firms have compulsions, but we have to explain to our overseas counterparts that India has its own set of concerns and issues, and therefore, while privilege is available to us, we have to be very careful in dealing with these issues. While you're engaging with investigating officers, you are asked to supply material. That can be done in response to a Section 91 or equivalent notice, or by search or seizure. In both cases, we must maintain a record. Clients often get upset with me when I tell them, please make a list of documents being supplied. So it is easiest for an investigating agency seizing a document to say, file 1 to 20 seized from client X containing 100 pages each. Even for the stage of scrutiny for supply of documents in the event of a prosecution, it is important to know what you have supplied, because lest it get lost with the investigating agency or damaged or destroyed, because there are very, very rare incidents where documents do get destroyed. So that becomes a very important issue, that you must, while handing over a document, next to your letter supplying the documents, an entire list, an inventory of what you're handing over, or even with a search procedure memo, try and get that inventory prepared, at least broadly, if not minutely, so that your client's interests are protected in the long run. Can you withhold documents? The answer is no. If you try and withhold documents, you can delay, you can buy time, you can take time to produce original documents, but withholding documents often leads to an allegation of non-cooperation, perhaps even arrest, and that has to be very, very carefully scrutinized and done. Now let's come to...
Can I just add there, what if it's an offshore client and documents are offshore and the client's offshore?
I was just coming to that. That's the MLAT. Okay. For offshore clients, the department has, any department has two ways of dealing with issues. One is the legal way and the other is the practical. The legal way is going through MLAT, or the letters rogatory process, which we are all aware of. The practical way is they will email the client, the overseas client, once or twice, or the overseas entity, which you can choose to respond or not to respond, or they can even go and serve you to the embassy or the High Commissioner's. But the route that they often take when frustrated is to summon the local representatives of the foreign entity and make them sit from morning till evening. And that's the reality of life. I mean, this happens often enough. And that itself, if they call the MD of the Indian subsidiary, the MD is going to go screaming at the top of his head to say, listen, you better do something about supply of documents because I can't take this pressure.
Right.
So that's the practical part. But they are supposed to comply with MLAT. So I must tell you, in the event they don't, as in all procedural issues and concerns, relying on the broad principles of Chapter 35 of the CRPC, which talks about accepting all irregularities in procedures unless there is a failure of justice, and the failure of justice of test is very high. So even for MLAT proceedings, even if it's not regularly obtained evidence, courts have often allowed it to be admitted because of the 1974 principle. There's that Jain principle of 1974 Constitutional Bench. So it will have to be seen now in terms of the privacy judgment, the 9 judges on privacy. But broadly till now, courts are fairly liberal in allowing irregularly collected evidence. And this irregularly collected evidence is only to be tested at the stage of trial for admissibility or relevancy. I hope that answers the question.
Thank you.
Now, 2 more issues which I want to talk to you about on legal representation, and then just a few points to wrap up. The choice of legal representation requires 2 things. It requires an in-depth understanding of the relevant jurisdictional domain you're dealing with, which is a criminal prosecution and criminal investigation. There are 2 kinds of lawyers practicing criminal law, though we are often referred to as criminal lawyers, which is not entirely accurate. But lawyers who practice criminal law often deal with investigations, but most do not. Most are very happy doing trials and prosecutions. They have no interest in investigation. They believe that's below their dignity. But the investigation, increasingly, especially in commercial cases, requires an understanding of the commercial aspects of law as well as of the criminal procedural aspects. So you must have adequate, the client must have adequate legal representation, and there must be an integrated strategy, often with technical experts from the field of accountancy, from the field of technology, and law, and definitely on the commercial side, and even very often from business processes. I'll give you an example. When I argued the Bhopal gas case in the curative petition, the criminal curative petition, it took us 3 weeks to understand the chemical reactions that could have taken place and what the nature of the offense was. And I had to rely on my schoolboy 11th and 12th class chemistry to understand it, but we had technical experts explaining it to us, so that once those, even when those questions arose, and some did, we were in a position to explain that to the court as to what the factual aspect of the matter was, because the document said something, but we needed to understand go beneath and below the documents. Secondly, in terms of legal representation between a company and its officials, there are two sets of provisions which we must be concerned with. One is if the general criminal law applies, which is conspiracy, common object, common intention, IPC. The second is the vicarious liability provisions, which are Part 1 and Part 2. Part 1 talks about persons in charge and responsible for the day-to-day affairs. So you are prosecuted by virtue of status alone. The second one is not the second part of the vicarious liability, when you're prosecuted for acts of omission, commission, collusion, negligence. Now, if you come to the first part of any vicarious liability provision in any of these statutes, special statutes, even the Negotiable Instruments Act or the PMLA, you will find that there is an exemption clause that a person who's prosecuted, an officer in charge, let's say a director, he or she can show that they acted with due diligence or that they were not in collusion with the others. So very often, there may end up being a distinction in the requirement of representation for an independent director, a nominee director, and a promoter director. That's the first distinction to be drawn. The second distinction to be drawn is between the company and the independent and nominee directors, and even between one set of directors. Let's say, in a family-run concern, a family appoints their young 21-year-old college-going children and their spouses, male or female, to be on the board of a company who have no knowledge of that particular business. They may have knowledge of other businesses. Now, they may have a defense. They have a defense, in fact, to say that they are not aware as to what the governing mind of the companies were doing. Secondly, as I said, for an independent or a nominee director, you've seen 149 of the Companies Act, the New Companies Act, that provides an exemption clause as well. So this distinction will have to be drawn between these classes, and sometimes between companies and directors also, because the company may not want to support the stand of a single individual who according to it has committed an offense without the knowledge of the board of the company. So the converse, that is to say, distinct representation from the company and who the company believes may not be so termed, is the principle of it. So these are broad issues. Of course, where company decisions are attributed to the entire board, there must be a commonality of defense strategy, and people must not fight their own battles, because that leads to a lot of messes more often than not, because people start putting blame on each other, and the result is that the whole ship goes down. So in short, I'm going to conclude by saying anybody facing an investigation or getting a summons must not treat it lightly, approach counsel at the earliest, adopt a cooperative approach with the investigator, but be mindful of your potential weak spots. The primary objective must be to try and succeed closing the investigation at the investigation stage itself. That is by putting enough exculpatory documents which can close the case. If you realize that you have committed, if the client has committed an offense which is impossible to defend, then we fall back in the old Indian strategy: delay and buy time. Two more points and I'll wrap up. Non-compliance of letters rogatory or an MLAT request does not lead to an inference in favor of the defense that the evidence can be excluded. And lastly, as I said, legal representation between directors, independent directors, nominee directors, company will have to be considered on a case-by-case basis. So that's where I'm going to wrap up, and now I'm leaving the floor open. Questions? Give me a second. I'm just going to change the speed of the fan. Give me a second.
Absolutely. Thank you so much. In fact, we have a lot of questions flowing in. Alipak, is it okay if I take the questions and then bring you in?
Yeah, I think Pratibha, you go ahead with the questions. because his topic on director liability, vicarious liability is also covered. So,
Yeah.
Okay. I think some of these questions have been already answered. For example, can the reason for investigation be asked from ED? I think Siddharth already mentioned that you have a right, you can go to court, whether or not you will get it is a question. But there are other questions. One interesting one what is in terms of what is the role of the complainant in the proceedings as far as FEMA is concerned. Can they intervene? Can they ask the authorities to speed up the matter? Do they have any role?
In what case, the role of a complainant
In FEMA matters in front of ED?
very important. Complainants have now been given greater rights under the CRPC, but not necessarily in the special laws. Having said that, the role of a complainant has, even in an IPC prosecution, has recently been dealt with in a judgment called Rekha Murarka. I would recommend you all read it. It's a judgment of Justice Deepak Gupta and Shantana Gaur. Shantana Gaur was written it. I did happen to argue the matter. But when you read it, please note that the original version of the judgment will say it was dismissed, but actually it was disposed of because certain directions were given. So there is a correction order which is later passed. You will get that online on the Supreme Court website. Please consider that judgment. The right of a complainant is, in terms of 24(8) of the CRPC, they can assist the prosecutor during a trial. They can put questions to the prosecutor. They can file written arguments. They can point out to the judge that the prosecutor is messed up or things that the judge is messed out. So that can be done. Even during investigation, they can cooperate, support the investigative process. They have a right to support it. They have a right to seek monitoring of an investigation under the normal law in terms of Sakiri Vasu's case. So that is what they can do, but they can't override the prosecutor or take over. But that's the broad issue. In FEMA, it is a state-run prosecution. As I said, special law, so the complainant's role will be very minimalistic, but we'll have to see how Rekha Murarka's decision plays out in cases such as FEMA. You must also remember that till recently, FEMA did not have a criminal prosecution. Now it does. Now those have yet to be interpreted and seen.
Got it. Thank you. There's also another interesting question on law firms. So we had recent instance of law firms being raided by investigation agencies. So just your view on how they managed to breach privilege in that case, because that's very important to your point earlier, right? Where you've created documents for clients and you have access provided to them to investigation agencies through these raids.
Look, the question is, this problem about raiding law firms is not new. It's lawyers and law firms have been happening over the last 20 odd years, off and on. Earlier, the police used to be very, and police normally do not visit lawyers. They have a healthy respect for lawyers and law firms. But that has changed with the investigating agencies who believe that if they need to investigate lawyers or law firms, they will do so. In fact, in Calcutta, the SFI, if I'm not under the PMLA, or maybe the Companies Act, PMLA, notice was issued to certain law firms and they had to go to court to get a stay on it. The reason is because the powers are immense and these statutes are very broadly worded. So a lawyer receiving tainted money can also be questioned about that tainted money. If you receive fees from tainted money, you have to explain how you receive it. And that becomes an issue for lawyers. That's something which eventually the clients are going to pay us fees on them. Even if it's a bank-to-bank transaction, that becomes a As I see it, these agencies are becoming a lot more isn't about raiding or proceeding against lawyers, and the kind of respect and immunity, practical immunity, not just legal immunity, to a great extent. Rightly pointed out, there have been search and seizures. Eventually, is going to be two kinds. One is an overreach by an investigating agency, which is possible. The second is, as a lawyer, if you have, for example, I'll give you a practical example. As a law officer, when I was working with the government, I was asked to give opinions on a routine basis. Now, on one occasion, I gave an opinion to a public sector entity, and the public sector entity wanted to pay monies to X. My view was actually they had to collect money from X. They came to me with 3 opinions asking for monies to be collected from X. Monies to be paid to X. And I said, listen, I'm sorry, I don't agree. There was a very eminent lawyer of Calcutta, and I overrode his opinion. My clients went away unhappy. So but there are other instances where you will sign off on an opinion to allow a client to take a certain course of action. And if it is a public sector or a government client, you have to be very, very mindful of 2 things. One, the integrity of your opinion. It must be legally justifiable. Secondly, it must disclose all conflicts. So I can share with you this. So, there was the Passport Seva Kendra. Have you heard of them? There was an opinion that was sought from me about Passport Seva Kendra and about certain, about their contracts when I was a law officer. And I spent 2 paras mentioning to them that I'm giving this opinion, but please understand, I've been a retainer for Tata's and TCS before I joined the government for 4 years. Since you're insisting on the opinion, I'm giving it to you. Now, you must show that level of fairness, because the moment it comes out later, it's going to be treated as if the client's conduct is. As a lawyer, have you facilitated a certain course of action by your clients or one of the parties to a transaction, which can lead to an allegation of an offense against them, and for you as having facilitated or supported that offense? By way of example, a lawyer giving a report on a property regarding a client, regarding the nature of title on that property. Such a lawyer can get prosecuted, can't he or she? If the report is either inaccurate or wrong against the state of affairs, or showing the property is unencumbered, whereas it actually is. I hope that answers your question.
Absolutely. I think we will have to take another session on this, because, obviously as lawyers, if I'm taking money through banking channels and I've checked on the integrity of my client, which we do. And of course, the integrity of our opinion is not a question. We will not give an opinion unless we have a view that we can endorse legally. Then it shouldn't be a defense. It should be, we believe that nobody should be able to enter our law firm, no investigation agency, unless they have proof that we will then have to rebut. So I'll leave it at that. I think we will need a full session, because this is very close to
I'll just respond to that. So let's say you draw up documentation for a client. Now, you're drawing up documentation for a private client working with the government, or for the government based on a certain, the government says we want to enter into a certain contract. If that contract favors a private party, contrary to law, that contract is going to be called into question. At that point, you are a person of interest. You may have done. I'll give you an anecdote. About 20 years ago, I was sitting in the office with a partner of a law firm, and there was a contract which was signed up, and on reading it, I felt that it could be misread by an investigator, and there was a prosecution liability. During the lunch break, the gentleman got up and told me to take his side and told me, he says, Siddharth, you're reading this contract in a manner in which it was not meant to be. My answer to him was, I am reading it in a manner which I believe an investigator is going to And if an investigator reads it the way I'm telling you, you will have a problem in your hands. Client will have a problem with that. So therefore, as I said, we must ensure that as professionals, we maintain the straight line, not the dotted line, between our clients functioning and our role as professionals. The moment you cross that role, you run into a gray area. I'll give you a classic example, Pratibha. All of you, in the Bhushan Steel case, I'm coming to that example again because it's a case where you have 287 accused. Do you know how many of them are accountants? Almost half. These are all, and they must be about, and I'm not talking about the in-house professionals, right? These are all external professionals for one or the other company. Some having acted in good faith, some having acted negligently, some having colluded.
Understood. Moving on to the next question. Just question on you already again touched on this, right to be represented even at interviews, meetings conducted pursuant to summons. But practically, again, agencies will make you either sit outside or even just say lawyers can attend, come alone. Practically, what you do, the example given here is of SFIO.
You have a right to be in sight, but not in hearing. That's the norm. That's why I said read Nandini Satpathy, sight but not hearing. And if the agency doesn't cooperate, then you have to get an order from court. You can get it in writ, you can get it from a magistrate's or a special judge's court, but you can get it.
Understood. The next question is, you touched on a very important topic on FCPA investigations and the reports. That's something that is a very important aspect for all our foreign clients. We do a lot of that work. So how do we resist disclosing an internal investigation report under FCPA? Can we just say it's through a law firm? And if the in-house counsel is also considered a lawyer in the relevant jurisdiction, it's with them. We've got enough lawyers, enough privilege. Would that be sufficient, or is there anything else you suggest?
Yeah, I'll tell you this. The problem arises when these are done through an Indian entity. So very often, one of the best advice is, let such an investigation be offloaded to a foreign law firm or a foreign entity which does the investigation, and therefore, and if that's permissible under FCPA, and if that can be done, and the investigation is carried out in India but by an overseas entity, and the records in the rope is kept overseas. The records in the report is kept overseas, which the Indian entity can then say they do not have access to. What they will have access to is the persons questioned, the list of the persons questioned, their employees, and the documents scrutinized. That you will not be able to get away from. To that extent, you can cooperate, but you can always, if you create that barrier overseas, you can always take a stand that the investigation having been done externally and having been maintained abroad is not available to the Indian corporate entity, and then they can keep chasing the principal for a couple of years.
Understood. Thank you. I know you have to go in 2 minutes, so last question, and apologies for those whose questions we didn't.
No, my apologies. I took time. I got stuck.
No, we are very thankful. This is, if you were charging us for this would have been very expensive time right now.
I thought about it. I thought about it. Imagine sending 400 bills to 400 lawyers. I would have been a rich man. And these days,
I know we still have, after almost 1.5 hours, 160 participants online. Again, a practical question that we will not find in CRPC, right?
Somebody said checks in the mail. Tell him the post offices are functioning. I'm waiting for it. Satyajit said checks in the mail. I'm waiting for it then.
Satyajit, we have your email. Therefore, practically, how do we communicate with ED? I know how we do it. As soon as we get a matter, we come to you, right? But a question that has been asked is, like how especially with ED matters, right? They never wind up. They've been pending for 10 years, 15 years. We don't get closure. We have cases where we've had directors of RBI who are named in a case and they have to discuss it in all sorts of places, but we can't get them a closure. We can't even get them to talk to each.
Now, this is at the investigation or post-investigation?
Post-investigation.
Just give me a second. 5 minutes. 5 minutes, I'm on another. Sorry, my other summons are coming. Just give me a second. Give me 5 minutes. 5 minutes, guys. 5 minutes, please. Sorry. Yeah. Tell me.
So how do we get a closure?
How do we get a closure? I'm sorry, I asked you investigation stage or post-investigation?
Post-investigation.
Post-investigation, unfortunately, as you know, we've had a problem with processes in terms of the way matters linger at the adjudicating agency, then at the appellate stage. That's a larger systemic issue. Now, we will have to keep plodding away at these issues because, unfortunately, the way the tribunal has been functional, the appellate tribunal, even for PMLA or for FEMA, though it had a chairman for the longest of time, while Justice Manmohan Singh, and he was quite efficient. Eventually, what was being determined was interim orders because of the pressure of work. And that's a systemic issue. But having said that, we can always try, if we are finding no traction at the tribunal, to take the matter to the High Court, try and seek a quashment or something, based on the case-by-case cases, or seek an early hearing, challenge that early hearing, and try and get things expedited. Having said that, a direction which a tribunal considers hostile to itself and its board is not necessarily always a pragmatic thing to do. While, you know, I'll tell you, in the early years of my career, I did a case for a French bank, and there was a lady who was coming on the board of a public sector bank through the RBI, and she needed that case finished. It had been going on for 20 years. I was lucky that, you know, we managed to get it finished in a year's time because she was up with the Ambanis who were her co-accused and they were never letting it go. We went to the High Court, got a direction for early consideration of her petition, and it was finally considered. She got off not in 3 months, but in 6 months, and finally she was off. We will have to think out of the box, and these are strategic calls of when to push, how to push, where to push, and how many times to push. Because if you push too often, then sometimes even when you have a genuine reason to expedite a matter, you will not be able to get it. So it has to be a strategic call when to push and what chances to take. That's an individualistic issue.
Absolutely.
And based on the jurisdiction and the roster of a court.
And 90% of the times we tell clients, let the matter lie. You really don't want an action to get worse against you. Right now, the file is, if it's lying for more than a year, just assume it's closed and move on with life. I cannot thank you enough for joining us today. I know we ran out by a couple of minutes, but Nishith bhai, I think you want to make concluding remarks really quickly.
Siddharth and everybody on the panel, it's been wonderful. I've been on this WebEx throughout, right from 1 minute before you started. It is so interesting to hear you all. Always, pleasure. And just cannot thank you more for coming over to spend so much of time with us. And I don't know, we have some 400 people somewhere on the WebEx, and I'm sure that so many people benefited from your conversation today. And even then, we are not feeling bored listening to you. And, but somehow or the other, we have to call it an end for today. And I want to thank you so much, Siddharth. It's wonderful. And Pratibha, Payel, and Alipak, and Vyapak, and everybody, and all the participants, thanks a lot. So thank you, Siddharth, once again.
My pleasure. And sorry I was late once again, but I must tell you, it's a pleasure, and I've tested your patience by keeping you off. At least some of you are in this jurisdiction, so it's a hot afternoon when work is off. So everybody's been very alert and kind. Thank you so much. I could see the flurry of messages, so I figured what you can do is, Pratibha, if you want to compile these questions and send them to me, I will try and venture and answer them as best as I can.
Thank you so much. That's really kind of you. We will do that, and if anybody has any more questions, we'll just post an email address here where you can post your questions.
Yes, my request is just compile them, because I think there'll be some amount of repetition. So if you can compile them under different heads, and I'll just try and answer them as best as I can.
Wonderful. That's
we should have only questions and answers only. Now that the background has been set, we can have special question. Thank you. Carry on.
Thanks, Siddharth.
Thank you.
Thank you so much.
Thank you so much for joining.